public session. I'd like to welcome Mr. Jim Murray, Chairman of the Pensions Council, and you're accompanied by Ms. Roma Burke and Ms. Kirsty Flynn. And I'd also like to welcome Mr. Tony Donoghue, Head of the Education and Social Policy in IBEC, accompanied by Ms. Maeve McElwee, Director of Employer Relations. I'm going to invite the two presentations, and then a number of questions will be raised. So in the first instance, I'll ask Mr. Murray to make his presentation, followed by Mr. Donoghue. I'll then afford questions to my colleagues here, and any of you feel free in terms of the response. They're not, they're not restricted to any one of you. Any of the panel are more than welcome to contribute. Before you make your opening statements, I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter, and you continue to so do, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person, persons or entity by name or in such a way as to make him, her or it identifiable. And members are reminded of the long-standing practice to the effect that they should not comment on, criticise or make charges against a person outside the House or an official, either by name or in such a way as to make him or her identifiable. And once again, colleagues, if you have mobile phones, you might turn them off, please. Mr. Murray, would you like to make your opening statement?
Chairman, first, thank you very much for inviting us here. I'm speaking, of course, on behalf of the Pensions Council, whose sole function is to advise the Minister for Social Protection, Employment Affairs and Social Protection on pensions generally. As I told you in my opening statement, the members work in effect on a voluntary basis and do most of the work, as no payment is made to members, and we don't have a secretariat as such, but we do have some support on an administrative level. We wouldn't usually look at something as specific as this, but rather put forward some general ideas, but since we were invited to do so, we considered the text of the bill at the April meeting of the Council. And it's a part of a number of efforts, and we do need efforts to improve protection for members of defined benefit and indeed other schemes, if I may say so. So we very much welcome the objective of the bill. In large measure, at least as far as the first section is concerned, it's the so-called equity as between the different kinds of pensioners. We assume that that at least applies mainly to the wind-up of insolvents. It doesn't apply to the wind-up of insolvent schemes, because the allocation is specified by statute at present. Overall, and this was looking at the overall field, we felt that the best starting point in dealing with the issues raised here would be to start from the principle that DB fund deficits should be treated as a debt on the sponsoring employer, and that would be the starting point. That's not to say it has to be applied in every single instance, because sometimes you have to adapt to particular cases, but we feel that is the best starting point for considering all the issues in this area. Now, the bill would certainly create a debt on the employer in relation to fund deficits in certain cases, and it should be commended on that basis, but it doesn't fully embrace the approach that we propose. But there are also a number of legal and practical problems with the bill as drafted. It may be that they could be fixed or not fixed, but it did seem to us, as we tried to work out, and remember, the Council consists of, part possibly from the Chairman, of a group of the most experienced, most expert people on pensions and pension policy in the country. But when looking at Section 2, and that's the new 48C, we weren't sure how one could get a majority of members of a pension scheme, because there are three groups of members of a pension scheme: the pensioners, the active members, those still in employment in effect, and deferred members who will still have some rights eventually when they reach retirement, but who are not accruing benefits in the normal way. So one would have to ask, well, is this a provision that's just to apply to one group of pensioners or to all? And particularly in relation to the deferred group, overall, the number of deferred benefit pensioners is very much higher than the number of active and members and pensioner members combined. They're a very large number, and some of them at least may have been dispersed to the four corners of the earth, so there may well be problems in that. But let's just try to work through. Let's say it's only the pensioners who could object to the way in which the funds are allocated. Okay, they'd make the objection, according to the scheme of the bill. Now, they'd be appealing for reallocation of what in most cases would be a fixed amount of money. So they'd be asking, any group appealing would be asking that money be taken from another group and given to them. And the problem there, of course, is the other groups would then have to be heard. And what's equitable for a pensioner may not be equitable for an active worker and an active member, and may not be equitable for a deferred member. So there'd be potentially three groups of people, all making probably perfectly plausible arguments, but from their perspective as what's equitable. The non-pensioner group might point out that the overwhelming balance of any money in a fund is paid to the pensioners, and the per capita payment made to pensioners in such cases is far higher. Is it 12 or 6 times higher? Anyway, far higher than the per capita amount paid to active members or deferred benefit, the deferred members. So we see that this is not really something that the Pensions Authority could act like Solomon and say, well, this is exactly how it should be, and so on and so forth, and certainly couldn't do it without the risk of legal challenge. If you understand, get the point of it, when we tried to figure it out, it just wasn't clear how it would work in practice. On Section 3, in relation to 50D, well, it meets, in one sense, part of the general principle that we like, which is that the deficit should be a debt on the employer, but only in part. But we think also it may pose practical problems or difficulties for the Pensions Authority, who would have to decide in a very public way and declare that a fund was solvent or not solvent, and with the possible consequences so far as that was concerned. And we felt that the existing Section 50 of the Act, which provides for what I'd best describe as an overall review or check by the Pensions Authority on how a scheme is to be restructured, is probably the best way forward, although it has to be said that the main concern of the authority, perhaps rightly, is to ensure that there's enough funding left to fund whatever has been decided in terms of restructuring. Finally, and I can't really emphasize this enough, we consider this as one meeting. We consider it in a very general way, and there are many, many details that would have to be filled in terms of applying this system, particularly, say, for multi-employer schemes and the like. And also, certain procedural rules for wind-up would need to be required and indeed improved. Particularly, for example, in relation to wind-up, there should be a clear period of notice and, in effect, an opportunity for the different partners, the different members to make their views known. And also time so that they could, in proper cases, try to trigger the informal dispute resolution system that is that is there when there's a dispute between the trustees and the employers. And of course, in all of this, everything that we look at has to be looked at in terms of the fact that a pension scheme is a contract, a private contract, between the trustee and the employer. Yes, there's regulation applied by the authority, but that is it in essence. And we would wonder whether the authority could, in those circumstances, for whatever good argument, we'd wonder how the authority could insist that an employer should continue to pay into the scheme ad infinitum, so to speak, and what's a private commitment. Now, there may be things in the trust deed that impose certain duties on the employer, but that's specific to the particular scheme, the particular trust deed. But to give an authority the power to insist that somebody should honour a contract ad infinitum would certainly pose difficulties. We don't know what exactly the situation would be. But I'd end just by repeating the point that we've looked at this in a general way. We think that the idea of starting with the deficits as a debt on the employer, within that dealing with specific hardship cases, if I put it that way, or particularly difficult cases, would be the best approach to this, although an awful lot of work would remain to be done on it. Thank you very much, Chairman.
Thank you very much, Mr. Murray. Mr. Donoghue.
Thank you very much, Chair. And again, I'd like to thank the Joint Committee for the opportunity to address you on an important issue for some very long established and strategically important businesses within the IBEC membership. The last time on which we provided an input to the committee on a defined benefit pension schemes was in relation to the head of the government's bill in June 2017. And our concerns with that draft bill and the current bill under consideration, the Pensions Amendment Number 2 Bill 2017, they're broadly similar. And these concerns principally relate to the unintended consequences, potential risks and practical considerations from Part 3 of the bill. This proposes that it would be illegal for a solvent company to wind up a DB pension scheme without the consent of the authority, so-called employer debt. Before looking at the practical implications of this, and Mr. Murray has highlighted some of these, it's worth remembering that most DB pension schemes are established under a trust deed. The employer undertakes to be bound by the rules of the scheme and to meet certain duties and liabilities on a voluntary basis. There has never been a statutory obligation on employers under Irish law to contribute to a DB pension scheme, nor to accept liability for any deficits. So this bill would turn a voluntary contribution into a mandatory obligation and potentially jeopardise the viability of businesses which are unable to absorb this extra cost. I was struck by some of the witness inputs on the employer debt during the Joint Committee's last session on April 11th. To paraphrase, they suggested that schemes have had plenty of opportunities to close or wind up. This type of legislation has now been under consideration for 2 years with no evidence of this happening. And schemes which now remain have already decided that they're in it for the long term. I actually tend to agree with that as a generality, but while that point was used at your last meeting to support the argument that we would make, that the risk to employment and business viability is exaggerated, I would ask then, what problem is the bill trying to solve? The bill proposes an unfair burden on long-established and highly reputable employers who voluntarily set up defined benefit pension schemes and have invested significant sums to maintain them through very difficult times. There would be no corresponding obligation on employers who have set up defined contribution schemes or that the vast majority of smaller businesses, particularly, who have no pension scheme at all. And just to give members some insight into the size of the cost and competitiveness implications, I'd refer to recent research by Roma Burke of LCP and Tony Kilhawley, which suggests that employer funding for DC members averages 7% of salary compared to 22% for DB members. And just as an aside, that does raise issues of equity within companies between different categories of employees within the same company. IBEC shares the committee's members' ambition to protect scheme members, to encourage employers to ensure that schemes are well funded, and to prevent employers who won't pay or who won't propose an equitable alternative arrangement, as opposed to those who can't pay, from simply walking away from the schemes they sponsor. But advocates of employer debt ignore the reality of business risk. They're asking companies to assume responsibility for factors which have undermined the DB pension model and are outside their control. Volatility in stock markets, demographic pressures of increasing life expectancy, falling bond yields, and regulatory requirements. As a small, open economy, Ireland is particularly vulnerable to uncertainty, global economic slowdown, and turbulent international trading conditions. We can ill afford to add unnecessary risk to our companies' balance sheets. Committee members will have already seen the figures on the long-term decline in the number of DB schemes in Ireland in the Library and Research Services briefing paper to you. We are, in effect, moving towards a long run-off phase for increasingly mature DB schemes, and we should be trying to nurse them through this process. And this will only be achieved by addressing the rules surrounding the funding standard and not by additional regulation. So that, in that regard, we welcome the proposal in Part 4 of the bill that the Pensions Authority should prepare a report on the feasibility of changing the way in which the funding standard is calculated. However, I'd question whether we require legislation to mandate this. The experience of recent years has demonstrated that DB schemes are best managed through discussion and negotiation between trustees, employers and members, whose efforts are made to reach agreement on the steps required to secure scheme viability. As we've argued previously, these steps may include a mix of measures such as increased employer member contributions, longer working and amended benefits. The painstaking process of supporting schemes to gradually move to a more appropriate funding level may not attract the same media attention as a small number of high-profile scheme closures. However, it's more likely to secure sustainable member benefits than additional regulation. The fact that almost 80% of DB schemes now meet the regulator's funding standards is testimony to progress that has been made. It's estimated that just 20% met this standard 10 years ago. While most of my comments have been from an employer's perspective, we shouldn't forget that this type of proposal could result in a far worse outcome for some scheme members, particularly younger members. In some cases, preventing an insolvent scheme from winding up can result in its ongoing deterioration before inevitable closure, with older members using up the assets before younger members retire. This point again was acknowledged in the Research Services briefing paper. To conclude, we believe that the bill will be unfair on employers who have voluntarily set up defined benefit pension schemes and invested significant sums to maintain them, unlike many of their competitors. The proposed legislation will destabilise future efforts of many employers and trustees to support and deliver on the pension promise made to scheme members. The pensions liabilities and investment risk assumed could be too big for companies to support in what can be a very uncertain business environment and could jeopardise the viability of the business and jobs of those employed. and if implemented, the bill will result in far worse outcomes for some scheme members, particularly younger members, whose assets could be used up by older members before they retire. So I thank members for their attention and look forward to answering your questions.
Thank you very much, Mr. Donoghue. Just one comment, and it's not for you to answer. You said most of your comments had been from an employer's perspective, and that's precisely why you're here. And I'm not being flippant in that regard. The committee has had a variety of witnesses who represent the views of different people. So that, you know, that is your role here today, and we fully acknowledge it. We expect you to represent employers. That's, I suppose, part of the consultative work that the committee would do. So I just want to put that. Deputy O'Dea.
Yeah, well,
I'll let Deputy O'Dea put his questions, and you might reply, and then I'll do Deputy Brady.
okay. Well, more comments, I suppose, really, than questions in response to what has been said. I mean, in relation to what Mr. Murray says in connection with Section 2, I mean, you will be aware that in a restructuring situation, the pensioners have no say. The pensioners have no say, and consistent representations have been made to us about the unfairness of this. So basically what we're trying to do is give them a say. Now, the wording might do with some amendments. You mentioned detailed rules and notice, etc. I would envisage all those sorts of things would be dealt with by way of regulation. I take your point about, you know, some of the deferred pensioners in particular, that they might be scattered all over the world. Well, you know, we have an election coming up here in a couple of weeks' time, and you know, some people mightn't be available to vote, but you know, the result will be from those who actually do vote. In relation to what Mr. Donoghue says, it's, you know, it echoes really the submissions you've already made, you know, in connection with this. And I understand the points you're making, and I do take the point that there is no legal compulsion, of course, to set up to provide for workers who retire by way of a defined benefit scheme. So, you know, by definition, I suppose an employer who opts to have a defined benefit scheme as opposed to some other employer who doesn't have any scheme at all, or a defined contribution scheme, that employer will be at somewhat of a disadvantage, competitive disadvantage by definition. What we're trying to get at here basically is, you know, solvent employers who can afford to continue with their contributions to the defined benefit pension scheme can literally walk away without let or hindrance. You know, employees join firms on the basis that, you know, we signed a contract and this is the salary, and we have a defined benefit pension scheme, etc. We're paying into that scheme. The employer is making their contribution, and suddenly, you know, at the sole discretion of the employer, the whole thing can be terminated. And I think that's unfair. And I think that if it wasn't unfair, and if it wasn't something that needed to be dealt with, we wouldn't have the legislation we have, for example, in the United Kingdom. And as the chairman said, previous witnesses in here have urged us to get on with this. Not only have they supported it, but they've urged us to get on with it as quickly as possible. Now, I take your point about solvency and a risk to the balance sheet. I've tried to draft it in such a way as that solvency would be protected, you know, that you can spin it out over a period of time, etc. It may be that we might need further adjustment. As you know, we're providing for an ultimate appeal to the High Court, and you know, maybe we could look at it in that context, that the High Court can look again at the, you know, at the overall threat to solvency of applying the legislation in a particular case. Risk to the balance sheet, I think, don't you have to provide for, if you have a defined benefit pension scheme, don't you have to provide for that in the balance sheet anyway? It's a contingent liability.
It's a contingent liability. You have to show it on the balance sheet, but I mean, funders, etc., or if you're looking to raise capital, it would be recognised as a particular type of contingent liability on the balance sheet.
Okay. You know, I take your point about the might situation arise where ultimately the scheme will fail, and younger members could be at something of a disadvantage because it would have been better for them if the situation hadn't been delayed. I take that point, but you know, I would say that if you took a poll of all the younger members of defined benefit pension schemes at present, they would prefer to have some type of protection in place. So, but I do. I mean, I welcome. First of all, thank you for. Finally, sorry, thank you for coming in, and I do welcome the points you're both making. And this is a pre-legislative session, which means that the next stage will be that the bill will go for detailed committee consideration, and no doubt there will be amendments in the course of that. So, you know, we'll take into account what you say. Other parties will put on amendments, and we will consider any reasonable amendments. And we will, I mean, as I say, our intention is not to drive any company into insolvency and create unemployment for their employees. We'll make sure that the final product is carefully drafted to safeguard against that.
To our witness, I'll come to you in a moment, Deputy Brady. To our witnesses, any comments in relation to Mr. Donoghue?
Yes, thank you, Chair. First of all, I'm assured by Deputy O'Dea's comments on solvency, but I wouldn't fully agree with the assertion that solvent employers can simply walk away from schemes. Schemes are governed by trust deed, which imposes quite rigorous requirements in terms of the trustees, and in some cases, in commitment from employers, and sometimes this can be actually exercised through it's not often done in the courts, but actually making a contribution demand on the employer that can be written into the trust deed. And I will invite my colleague Ms McAwee to talk a bit about some of the realities on the ground, but I don't, because they're normally handled through a process of negotiation and a very sensitive process with a lot of moving parts, and we don't want something that will actually destabilise that process. Look, DB schemes are set up to have a lifetime now by the very fact that I've seen different figures, but between 70 and 90% of them are not taking in new entrants anymore. So there's no new money coming into it. So again, and I've seen one scheme at relatively close quarters where the younger members were actually pushing for the scheme to be closed because they could see where it was going, and and also the fact that younger people tend to move around between different employments now as well, so they would prefer to have that control over their own pension pot, and to put it bluntly, they felt they were subsidising the significant pensioner liabilities on the scheme, so they felt that this was inequitable. I'd like to take the opportunity also, though, just to put in a related comment around this, in that the most important thing around this the complexity of pensions legislation is to do no harm and to minimise the unintended consequences. And there are business consequences here because of the, in some cases, the huge liabilities of these schemes. I mean, some companies look more like a pension fund with a company attached to it than a company with a pension fund. And so what might look like a solvent company, if this debt was to be actually brought in, they'd be very, very quickly insolvent, believe me. And the only way that you can negotiate out of that, and I've given some examples around looking at retirement age or looking at member benefits, is to let time take care of it. And you're often looking at a 10-year process to actually remedy this. And it's very difficult to know how any agency, and in this case it's the suggestion it would be the Pensions Authority, would be able to take a view on the solvency of a company 10 years hence. They could take a view in the immediate, but the immediate is very rarely that relevant to pensions discussions. And then, and this was an issue raised by the Taoiseach in a statement in the Dáil in response to questions. There are those other unintended consequences in that this bill, I mean, I'd be interested to know how it might apply to semi-state companies, because while it mightn't put them out of business, the legislation would make the company's debt so high that it would be unable to invest anymore. And that would have a serious impact on the public good, because large state-owned enterprises need to be able to borrow to invest in infrastructure. And if they can't do that because of the pension scheme deficit, has come onto their balance sheet, that would actually create societal problems as well. So I just put that one in there just to show that the unintended consequences that would potentially come out of this. But perhaps, if you don't mind, Chair, my colleague, Ms McAwee, will just, who works with companies, you know, who are trying to go through this process, would reflect on the realities of it.
Thank you, Chair. So just a couple of quick points, I suppose, to pick up on the issues that have been discussed. And I suppose realistically what we see in organisations where there are defined benefit pension schemes in place is, to the point that the Deputy has made, they were employers of choice. They are employers who have put in place significant benefit schemes. And I suppose I would pick up on the Deputy's use of the word who opt, because actually it's a past tense, who opted many years ago for these schemes at a time when we were in a completely different situation. The challenge now is we couldn't foresee the future. We couldn't necessarily see the challenges that we're facing now. Lots of companies have no new entrants, as Tony has already said, coming through in this regard, and they are in a negotiated situation. And it is a very sensitive employer relations issue, and where you have a company who has already made the decision many years ago to be that employer of choice, to put in the best benefits that they could at the time in good faith. They are, of course, in every circumstance where that's feasible and possible, going to negotiate with their trustees and undertake a very significant programme of negotiations with their staff in respect of any changes, amendments or closure that has to come about based on the financial situation of the pension scheme as it stands. I think we do have to recognise that the world of work changes all of the time, and it is a private contract entered into freely and at the cost to the employer. And the reality of that is all contracts do change over time, and in every other aspect of employment contracts we do see changes that come about, and they do need to be open to negotiation relative to the position of an organisation at any time. And we see that as it comes through, and I appreciate the comments that have already been made around the fact that hard cases would have to be considered. The challenge, though, is how would those hard cases be determined, and how, in effect, would any organisation entering into these types of discussions be in a position to determine in advance whether they were going to be considered a hard case and given that opportunity to negotiate. So the challenges of trying to differentiate one between the other are really significant for businesses. Chair, maybe just finally to pick up on the point that Mr Donoghue made about younger members and your contribution on the fact that IBEC are here to represent employers, and that's absolutely the case. But I will tell you that in my position, dealing with the direct engagement with human resources directors in organisations all of the time, this issue of internal equity between different cohorts of staff comes up, and they feel, and we feel in advising them, a considerable responsibility about managing some of those challenges that come up between people who have significant DB contribution benefits and newer staff who have not been able to access schemes that are now closed, and the differences in the terms and conditions that apply there. And it is a very considerable concern for employers, for their own staff, and the particular concern around younger employees and newer employees into organisations being at a disadvantage, and the challenges that prevents for good and stable, harmonious industrial relations within their businesses.
Mr Donoghue?
Yeah, just a quick one, Chair. Apologies for coming back in. I was conscious that I didn't pick up on Deputy O'Dea's comments on the UK. And I just referred to the report last year from the Pensions and Lifetime Savings Association there, which there are 11 million people in the UK expect to receive benefits from a DB scheme. This particular report says 3 million of them have only a 50% chance of getting the received benefit. In other words, they have had employer debt in the UK, as you quite rightly point out, but the it hasn't actually solved the problem. The flight from DB to DC is actually accelerated in the UK, and they have serious concerns, and there's another proposal, that the Pensions Protection Fund over there will not have the resources or anywhere near the resources, and this is an economy of much larger scale than ours, to actually meet those liabilities. So the UK have gone down this route, but probably didn't get the results they were looking for.
Mr. Murray, do you want to...
Thank you, Chairman. In relation to pensioners having no say in restructuring, well, I suppose strictly speaking that's true if you mean that they don't have a certain established right, but in law or something like that. But in practice, and particularly if there is time is of the essence here. If an employer just in effect closes the scheme overnight before anyone has a chance to offer an opinion. Well, that must not be possible under any circumstances. So the question of time, and I think the Council would go along with much of what Mr. Donoghue said about the parties, the parties to the contract being the ones who should play a part here, and through the trustees, who after all are supposed to be looking after all of the parties in the scheme. So that, yes, it's not written into, but in practice, pensioners, and also let it be said, pensioners very often are a very organised group, a very vocal group, and perfectly entitled to be. There's no problem with that. So I think the Council would feel it was wouldn't be quite correct to say, without qualification, of course, that pensioners have no rights. On the issue of the younger members, I should expect the Council was perfectly well aware of the general arguments against many of the things the Council was for. They weren't entirely convinced by the argument that extending, when combined with a funding proposal, which would be hugely important, would necessarily be adverse to the younger members. But again, this is going to come up in the context of any restructuring scheme, particularly, and the younger members are well, they're going to be well able to make their voice known, since most of them will probably be, well, maybe active members. We don't know. The number of deferred members is so high. 400,000 or thereabouts against only 400, get my figures right. What was I?
100,000 around 100,000 actives and 100,000 ventures.
Yeah, it is. I thought I should be saying millions, but of course not. It's 400,000 deferred members, 100,000 plus or minus active members, 100,000 plus or minus pensioners. So deferred members are twice as many as the other set of members combined. But again, we think that the situation of whether a continuation of the scheme is very much to the detriment of the younger members. It depends on the case, and on the case it can be. The Council certainly didn't think it was something that would always have to be applied, and depending on the case, the parties will have plenty to say for each other, and perhaps particularly to the point when the Pensions Authority comes to review any scheme under Article 50, the first thing, or the only thing really, that the Pensions Authority must make sure about is that in any restructured scheme that it's sustainable, that there's enough funds or prospect of funds there to continue it. As for the others, yes, it's true that as Deputy O'Dea said, that elections and all this kind of thing, but these always have an influence. But having said that, and without in any way appearing to suggest that pensioners are well off, I mean, they're clearly not, but we have to go back to the point that 100,000 pensioners which is about 16% of the total number of members, share 59 or 60% of the funds available, and the other 500,000 pensioners between them have about 20 billion in terms of liabilities. So there is a huge loss, particularly to active members when a scheme is closed down, a huge loss. There's often a loss to pensioners, not always, but usually there is too, but certainly in relation to the loss of prospects for the younger members does have to be taken very seriously. Now, I'm not trying to put young against old, but from the point of view of a legislator or a government or whatever, well, one has to look at the overall situation. And I think you'd have to start on the basis that all three groups, all three sets of members of pension schemes, each believe that they are badly done by. It would be a natural enough sentiment to have, but a government or a law and the trustees have to look at the overall situation.
Thank you, Mr. Murray. Deputy Brady.
Thanks, Cahir. Look, well, I'll be fairly brief because I think a lot has been covered now at this point. I think just a few comments and questions, mainly to IBEC, Mr. Donoghue. I would say, and I'm not sure as to whether it's purposely being done, but I think you're, when listening to some of the comments there about the bill and, companies not being able to look into the distance when these contracts, which essentially they are signed off. And this bill has come forward. It's not the only bill. I mean, there's a number of bills. I've brought forward one. I think the Labour Party have brought forward one. Indeed, government we're looking at heads of bill as well. So, there are serious concerns here, and that's why it needs to be addressed. And we are all very aware of the high-profile companies in the recent past that have shifted from DB schemes to DC schemes, all highly profitable companies, and even looking into the future, I'm sure those profits are fairly secure. So look, I mean, your comments there, I think, whether you're deliberately trying to muddy the waters or what, but there is no attempt to force employers to establish or pay into a DB scheme through this bill. Employers establish DB schemes through their own will, and they pay into them through their own will, and this bill will not change that. That will still remain to be the case. This is about solvent companies who are choosing to renege on their pension commitments to employees, not out of financial difficulties, but essentially to remove the risk from their own books, and that's the issue here that this bill is trying to address, and the other pieces of legislation that have been brought forward as well. And I think IBEC are deliberately trying to mislead the matter on that. So can I just ask, what is the view of IBEC in relation to the highly profitable companies that have wound down their schemes, some very high profile companies recently? What is the position of IBEC in relation to those companies shutting down those schemes? And look, I'm not going to delay things. All the points I wanted to raise have essentially been covered. So I just really put that point to you. What is your position in relation to those companies, highly profitable companies? You say there's no need for legislation, the trustees, the protections are there. Clearly it isn't the case, and legislation is needed. So just to get your view on that.
Thank you, Deputy Brady. Mr. Donoghue.
Thank you, Chair. Thank you, Deputy Brady, for your comments. There's an assumption in your question that DB good, DC bad. And that's not actually the reality. I mean, because defined benefit as a model has been shown to be unsustainable. And as I said in my opening comments, we've got to nurse its long-term demise in the most sensitive way and fair way possible. When there's no entrants coming into a DB scheme, there's no new funds coming into it. By definition, it can't carry on. You know, at some stage in the future, no new members, and the last pensioner passes off this planet. So there isn't. It's an unsustainable model, and you use the word risk, and that's the most important word on this. I mean, highly profitable companies removing risk is a legitimate business action because they want to maintain their profitability, and more importantly, they want to maintain their sustainability as well, apart from the issues of internal equity, where in most of these companies now, you've got two groups of workers and you're trying to manage that, some on DC, some on DB. So there is that. So there's it's perfectly understandable that they would try to remove that risk, and they should be supported in doing it. Now, that is not to say that they should be walking away from their commitments. And if you look, and we're not going to comment on any particular companies, but if you look at some of these highly profitable, high-profile cases, you will see that these negotiations, there was nobody walking away from anything. These negotiations literally went on for years in some cases. And in other cases, the outcome was, I would argue, much better for the workers. I could think of one company where their contribution to DC was actually higher than what they were paying into the DB, but they wanted to remove the risk. And the risk is the most important thing. And there's nothing wrong with that. But that's not the same as saying they can walk away from their commitments without putting a viable and equitable alternative in place. Because DC is the way of the world. This isn't just an Irish phenomenon. This is across the globe. And, you know, some countries, and Australia comes to mind, have had DC funds as part of their pension structure, paying very good pensions for 3 decades now. So I question the assumption that DC is necessarily inferior, and I would also, whatever about, you know, the risk part of it, I'd also argue that it is a more realistic option in this new world of work where people are going through multiple careers.
Thank you, Mr. Donoghue. Deputy O'Dea.
Just to take up on a point there, you said in response to Deputy Brady that, you know, we can understand why companies want to remove risk, etc. But it's not a question of taking risk and sending it out there into orbit somewhere. What you're actually doing is you're moving the risk from the company or the pension fund to the employee. That's what you're doing, essentially. And you know, people can argue back and forth about, you know, whether that's a good thing or a bad thing in an overall context. But just a couple of other points. I mean, you mentioned there that sometimes employers are constrained, solvent employers, who can perfectly well afford to keep a defined pension scheme in operation, that sometimes they're constrained by the trust deed. Well, sometimes, yeah, it depends. It varies from company to company. Every trust deed is different. I've read a lot of them myself in my time. And, you know, some of them clearly aren't. And it has happened. It has happened. I mean, negotiations, there have been some negotiations, etc., but it has happened, actually. You know, it has happened here. People have sort of unilaterally changed over to DC, where the whole risk is on the back of the employer, and the employee, and he's depending on whether the people who are investing the money in bonds or the stock market or whatever are successful or unsuccessful. And we have an awful lot of examples of where they were spectacularly unsuccessful, you know, and ordinary people are, as we speak, even bearing the consequences of that. Now, in relation to the point, I mean, all this conversation too is in the context of the obligation I'm seeking to put on the government. You say it doesn't require legislation to examine the minimum funding requirement. You say it doesn't require legislation. I say it does. Because if it didn't require legislation, we're beating this drum now for the past 5 years, and there's no sign of the government doing anything about it. So the only way to make them do something about it is to put it into legislation and compel them. And I think you will agree with me that the way liabilities are measured at the moment is daft. If I want to put it in the vernacular, daft. I mean, it's and you know, when you talk about those huge debts and, you know, overhanging companies and overhanging pension funds, I mean, it depends on how you calculate it. And if it's calculated in such a way as that is in reality, that the reality is that it's grossly exaggerated, then naturally you're going to have this continuing problem. I also take your point about the situation in the UK, which I've been following closely. You say that it hasn't solved the problem in the UK. Of course, it hasn't solved every problem in the UK, and this legislation, or Deputy Brady's legislation, or whatever legislation ultimately becomes law here in this country, won't solve the problem entirely either. I mean, because in some cases the company will not be found to be solvent, in some cases the risk will be found to be too great, in some cases they just simply won't be able to make up, you know, maybe because of the profit flow in the future. So, you know, I mean, if you had the guy in here who drafted the 10 Commandments, he wouldn't be able to draft legislation that would solve every problem in every instance. But what we're trying to do is to solve a particular problem, namely that companies who can well afford to keep a defined pension benefit scheme going feel that it's better for their shareholders, etc., and better for their own profitability to just walk away from it and replace it with a DC scheme where the employee carries all the risk.
Deputy O'Dea. Mr. Donoghue.
I'll take the minimum funding standard point first. I bow to your judgment on whether it needs legislation. I would agree fully that it should be reviewed. Yeah, it should be reviewed because, and the OECD has had comments on this, that it should reflect the long-term cost of the scheme rather than a snapshot at a particular time. It doesn't reflect the reality of buying annuities when you go actually out to buy annuities in the event of a wind-up. So you need that. The risk reserve calculations don't make sense either, and you need that sort of flexibility on valuation dates as well, because now this needs to be a fairly technical piece of work, but it seems strange that a pension fund mightn't look that bad in February, but by June it looks shocking because of the way the bond markets have gone, and the fluctuations are really significant. In terms of, I still take exception to this idea that employers can just walk away from schemes and there's no constraints on them. It may, as you say, you may know of companies that have done in the past. My argument here, and if you look at the rate of wind-ups, they've declined very significantly. You know, since 2014 there was 41 wind-ups. 2017 there's 16. I suspect there's even fewer in 2018. My point being that companies that were going to walk away from this less altruistically, should we say, would have done so a long time ago. There was 1,200 schemes 12 years ago, you know, and there's now 611 by the last data. So most of these companies have gone, they've moved out, and what you are looking at are very well, generally very well established, reputable companies. They're not the sort of companies that could, and have a scale that they couldn't just treat their employees that flippantly. And you know, pushing risk, the idea that DB schemes were out without risk, well, we've just seen they are actually really risky. We've seen what happened with wind-ups, where pensioners actually, actives particularly, saw their pension promise completely decimated. So that was a risk. The risk, I would argue, on the individual is more manageable. At least they're managing their own risk, and this is an important point here. They've also got to have the education and the advice on how to address this. And this is really important to another issue which I hope this committee will at some stage get a chance to deliberate on, which is auto-enrolment, where we will see, hopefully, a lot more employees with their DC pots accumulating, how that's going to be managed, and that's the model. You know, nobody's suggesting the 65% of private sector workers who don't have a pension at all, when hopefully when the auto-enrolment model is rolled out, and there'll be a big issue of education, the cost of advice, a whole range of issues in terms of mitigating those individual risks and making sure that they're informed.
Thank you, Mr. Donoghue. Mr. Murray, any further comments?
I don't think so, unless Deputy Brady would ask me to comment. But, look, nobody wants... sorry, wrong. No member of the council wants to see a scheme ending, but that's not to say that we think we can somehow pass a law which keeps a scheme in existence forever. It's a clear problem. That's all I can say, really.
Okay. Well, if that's the case, that will conclude. First of all, before I thank you, Mr. Donoghue, just to refer back to the auto-enrolment, it is a piece of work that is under review at this committee. It's with the Minister. But yes is the answer. This committee will be reviewing the development of auto-enrolment. And running in parallel, we've been doing a piece of work about bogus self-employment, because people who are in that category will fail to, or may fail to, benefit from auto-enrolment. So it's running in parallel. I'd like to thank Ms McElwee, Mr Donoghue, Ms Burke, Mr Murray and Ms Flynn for your attendance here today. Just to point out, this is pre-ledge scrutiny. The issues that you have raised have been helpful and informative, and as Deputy O'Dea said, the bill is not complete. As it progresses, there will be amendments either from the sponsor of the bill or from opposition members or from the government, and that's the impact and the feedback we're getting from the range of witnesses, and people come from different perspectives, and we specifically set the meeting up to get all views. So I'd like to thank all of our witnesses. To colleagues, just to say that we will adjourn. There's no further business, and our next meeting will be on the Tuesday, the 21st of May. Thank you very much.